In this case, my lord, municipality issued notice against me to demolish constructions which has been made in my Patta land. This petition was filed, stay was granted, but due to default of lawyer, case has been dismissed. So we have filed restoration as well as condemnation. It may kindly be listed on 25. Highly obliged.
May it please your lordship, one matter, my lord, pending matter. In this matter, my lord, I have been directed to file affidavit, additional affidavit that I have filed in motion, your lordship. Matter may kindly be taken up on Friday or Monday, my lord.
Which matter?
This is not in list, my lord. I am paying for listing. It was last listed on 27th of July, your lordship,
Listing for what?
for motion, my lord,
Monday.
Monday. Deep, your lordship.
I beg to mention item number 2, solution, today's list. It may be come up for admission. Already notice has already been issued.
1, 2, 3 are connected.
1, 2, 3 connected.
What's if in item number 1 notice was not issued. What's if issue notice and come up, and we have taken the plea of maintainability also. That may keep.
Item number 1, notice was not issued.
Yes. Notice may be issued and the lordship, all the matters may be
Taken up
for, may be taken together. The administration can-
Who is the counsel in item 1?
This is a service tax matter, lordship. My plea is that exempted turnover has been taxed. Item 2 and 3 are similar in which notices have been issued, lordship. So if the notices can be issued, lordship, keeping the plea of their mental alternate remedy open, then the matters may be taken up together, lordship.
All right, you take down hard Mr. D. Saraf, learned counsel appearing for the writ petitioner. The basic allegation in the writ petition is that the authorities have levied service tax on exempted matters in a manner which was impermissible in the eye of law. Full stop. Mr. Saraf has further submitted that similar writ petitions raising the same issue. Similar writ petitions raising the same issue are pending disposal before this court. Mr. S.C. Kyle, learned standing counsel, GST authorities, has questioned the maintainability of the writ petition on the ground that alternative remedy is available to the petitioner. However, the learned counsel for the respondent seeks some time to obtain instruction, file affidavit if necessary, comma. In view of the above, issue notice of motion returnable in 4 weeks. Since Mr. Kyle has appeared and accepted notice on behalf of all the respondents, no formal notice is required to be sent in this case. Extra copies of the writ petition, comma, requisiting numbers, comma, be furnished to the learned standing counsel. Registry to list this matter again along with WPC, along with item numbers 2 and 3, which are stated to be similar writ petitions. First up. In item 2 and 3, you write Mr. K.L. Gupta for the petitioner, so and so for the respondent, on the request of learned counsel for the parties, let this matter be listed along with items 1 and 2. And in item 3, who is the petitioner's
Dr.
counsel?
Saraf, I'm happy.
Your name, please?
PK Vora.
Mr. P.K. Vora Deepale, 2 or 1 logo delivery, same order. 2 and 3 eke order. Again, councillor naam to boli. Yes.
Lordship, item number 3, there is interim, your lordship.
Item 3, interim order passed earlier.
In 2 also, enter.
2 also interim order passed.
Lordship, in 1 also, if there can be no coercive measures till next day.
Yeah. All right, in item 1, you also write, since interim orders are operating in similar writ petitions pending before this court, it is hereby provided that no coercive measure shall be initiated against the petitioner until the returnable date.
Highly obliged, lordship.
My lord, I am for the item number 4, requisition for calling on record an affidavit in opposition filed by the
Mentioning is
respondent.
over, madam, you have to now wait. Mentioning is over. Yes, next matter, please.
For motion item 4. Item 4.
Yes, who is appearing? You write, none appears for the petitioner when the matter is called up. The respondent's counsel is also absent. As such, this matter stands passed over for the day.
Item 5.
May it please your lordship. Well, in this matter,
an appeal was fixed pending in before the registrar of cooperative societies. That appeal is yet pending.
Lordship, we have obtained an instruction, my lord. Last occasion, my lord has asked us to obtain an instruction. This is the instruction, my lord. We are going to have the hearing on 29th of 2023, my lord.
Even on the earlier date, the appeal was not heard and concluded, and the date prior to that. And this writ petition was specifically filed, praying for interim orders pending the appeal, my lord. May I pray, and on the other day, Lordship was also pleased to issue notice in the contempt matter, in the same issue against the person concerned. So what I'm praying, my lord, the operation of the impugn orders be stayed until the date within.
Well, we'll have it on 31st, but if no hearing takes place,
My lord,
then we'll suspend the proceeding before the registrar.
my lord.
That observation, if Lordship, my.
No, that will.
Ma-
Heard Mr. S. Bunny, learned counsel for the petitioner, also heard Ms. T. Bach, learned standing counsel. The Cooperation Department Assam appearing for the official respondents, and Ms. P. Bhattacharjee, learned counsel representing the respondent number 7 and 8. Full stop. Mr. ABT Hawk, learned counsel is present on behalf of the respondent number 6. Ms. Bach has produced a copy of the written instruction dated 21/8/2023, issued by the Additional Register of Cooperative Societies, to inform that hearing in the connected matter is fixed on 29/8/2023 at 11 AM in the office chamber of Register of Cooperative Societies, Assam. In view of the above and on the request of the learned departmental council, this matter is directed to be posted for motion again on 31st of August 2023 as a fixed item. Full stop. If no hearing takes place on the next date fixed, this court will consider passing appropriate order, taking note of the facts and circumstances of the case.
Obliged.
For admission item 6. Seven.
Please, your lordship. Lordship,
Yes.
in this matter, I'm appearing on instruction of senior counsel, Mr. A.M. Bora, who is on leave, my lord. Letter of absence submitted. May be passed over for today, my lord. Urgently had to
My
leave.
lord, in terms of your lordship's last observation, we are asked to come to a settlement and give it to him. I have come with a draft settlement. I'll give a copy to him. But when I talked to Mr. Bora last, I inquired from the Oil India Limited. They say that except my pension, the other benefits will be around 86 lakhs.
Around 87 roughly, not
80
beyond 90.
87 lakhs, he says. But the Bora was asking for 70 lakhs out of those 87 lakhs. But even then I'm giving, let them make a reasonable amount. Only now in the dispute is in regard to the amount. I'm giving the copy of the draft settlement to them. If they agree on the next step, your lordship
My
will.
lord, I'll obtain the instructions, my lord.
You are appearing for which respondent?
My lord, responded on behalf of Mr. A.M. Bora, my lord. the private
AM
respondent-
Bora is not a party here.
My lord,
I
the
want to
private
know
respondent,
which-
my lord. Private respondent. 7, my lord.
7, 8, and 9. 7, 8, and 9.
And subsequently.
And the
Mr. B.D. Kaur, learned senior counsel, appearing for the writ petitioners, established that in terms of the order dated 21/7/2023 passed by this court in these matters, he has prepared a draft agreement for settlement, for amicable settlement of the core dispute by and between the parties. Full stop. According to Mr. Bora, his client will be entitled to receive approximately 87 lakhs as retirement benefits minus the pension. And
No, ma'am, that's my submission.
yes, according to Mr. Kaur, that's.
Oh, I had Bora.
Oh, so, all right. According to Mr. Kaur, 87 lakhs as retirement dues, excluding the pension. And his client would be willing to part with a reasonable part with reasonable amount from the aforesaid dues if the matters can be disposed of on compromise. But, Mr. A. Sharma, Learned Standing Council, this is Oil India Limited and others appearing for the respondent numbers 1 to 6. Has submitted that the amount payable to the petitioner
In fact, I can place the computation sheet, the figure is there,
uh,
87.98.
minus the pension would be about 87.98 lakhs. In support of his above submission, Mr. Sharma has also produced the computation sheet, which I have gone through. Full stop. At this stage, your name, please.
Out of this, sorry, my lord, out of this amount, as on date, my lord, without prejudice to any of my lord, I'm agreeable to pay 50 lakhs, but then 30 lakhs will remain for
All
me.
right, Mr.
DK Boido, my
K.
lord,
Boitto, Learned Council appearing for the respondent number 7, 8 and 9.
789.
While seeking adjournment in the matter due to non-availability of the senior counsel appearing in this case, has sought some time to examine the draft proposal and come up with his response. Full stop. See, the said prayer is not opposed, same stands allowed. A copy of the draft settlement agreement prepared by the petitioner's counsel be circulated amongst the counsel for the respondents so as to obtain their response. Let these matters be listed again after 3 weeks. In the meantime, the respondents may also match the respondent number 7, 8 and 9 may also place on record the terms of settlement, if any, arrived in the matter.
Obliged.
Your lordship, may I pray for a date after, any date after?
A list after 3 weeks as a fixed item.
Item 8.
Yeah, please, your lordship. Lordship, as per office note dated 17/8, service is awaited upon the respondents, your lordship.
Services,
Awaited, your lordship, upon the respondents, 1 and 2.
heard Mr.
HR does it.
H.R. Das, Learned Counsel for the petitioner, perused office note dated 17/8/2023. Await service report on respondent numbers 1 and 2. Let the matter be listed again with appropriate office notes.
Obliged.
Item 9.
My lord, today fixed for instruction, my lord. And we're the members of the government shed, my lord. And Lord, my lord, though no fault on the part of the secretary, my lord, but wrongly held it was impugned that he has not followed the timeline, my lord. Despite having the timeline, he ought to have been held the meeting, my lord. We are aggrieved of this order, so we are before this court, my lord.
My lord, my instructions are to the contrary to what my learned friend has submitted, my lord. He did not adhere to the timeline stipulated in the act, my lord.
So according to them, the scheme of the time schedule in the act.
Absolutely wrong.
So we cannot decide this unless affidavits are filed.
My lord, in this case, my lord, if your lordship.
You are saying something, she is saying
No, no,
something.
if
How do
you-
we decide it on all?
Lordship, time limits, my lord, we brought requisition on 29th May 2003, time limit up to, my lord, 4th July 2023, my lord, with 4th July 2023, but impugn order passed on 30/6 2003, before completion of the time limit, my lord. So, my lord, absolutely, my lord, if your lordship, my learned friend fairness me instructed, I could file one against it report, I will file a affidavit, my lord.
I'll file an affidavit in the meanwhile.
I also file a counter reply on this one next week, regarding our summary.
All right, all right. Next week is not possible. You
Well,
may
sir-
have urgency. We
well,
don't
sorry,
have
sorry.
time.
That
You
may
cannot have
fix-
these matters every week.
That make me fix, my
Yes,
lord.
yes.
And
Or
other
Mr.
friend maybe
P.K.
ask me
Dekka,
to
learned
harness me
counsel
this
for the
report.
petitioner. Also heard Mr. Sharma, learned government advocate Assam, appearing for the official respondents who has obtained instruction as per the order of this court and placed the same for perusal. As per the instruction dated 5/8/2023 issued by the District Commissioner Hailakandi, it is the Secretary of the Gau Panchayat had failed to adhere to the timeline as prescribed by section 15(1) of the Assam Panchayat Act, as a result of which the authority could not take any action for convening this special meeting so as to discuss the no confidence motion brought against the president of the Gau Panchayat.
Yes, my lord.
First of all, Mr. Dekka has however strongly refuted such contention by submitting that the matter was placed before the district commissioner within the prescribed period of
Yes,
time.
my lord.
Full stop. The aforesaid controversy cannot be resolved unless affidavits are exchanged. In view of the above, issue notice of motion returnable on
Third day.
12th of September 2023, 13th of September 2023. Since Ms. Sharma has appeared and accepted notice on behalf of respondent numbers
2 and 3, madam.
2 and 3, and Mr. N.K. Debnath, Learned Standing Council, Panchayat and Rural Development Department for respondent numbers 1, 4, 5, and 6. No formal notice is required to be sent to the said respondents. Extra copies of the writ petition be furnished to the Learned Departmental Council so as to enable them to obtain instruction in the matter. Petitioner to take steps for service of notice upon the remaining respondents by registered post with AD. The official respondents to place their stand on record in the form of an affidavit on or before 11th of September 2023
My lord,
by
this-
serving advance copy upon the
my lord,
petitioner's counsel.
this report maybe kindly, my learned friend may be directed to furnish the source, my lord.
Share this with him. So
The
that-
instrument, I'll file an affidavit, my lord.
Before that, my lord,
Let him have a look at it.
My lord, my lord.
one copy of the protocol. Oblige, my lord. It's a copy, my lord.
Supplementary list for admission, I think 16.
May I please, your lordship? Lordship, the petitioner hearing is a registered buyer of respondent number 4 MSTC. So what had happened is that the petitioner for an
What do you say? Registered buyer means?
registered buyer, he is a registered buyer of MSTC. You have to you have to do registration in respondent number 4's website.
What is MSTC?
MSTC is an organization wherein they take various other organizations like Power Grid, Coal Day, scrap materials are sold over and they help in e-auction. The e-auction of scrap materials are done through MSTC. This is the process. So there were scrap materials of respondent number 1 and 2, the Power Grid Corporation. They entered into an agreement with MSTC for selling of the scrap materials. For this purpose, an e-auction was floated. Lordship may go, may you please to peruse annexure 2, page 30.
Just a minute, just a minute. Page 30.
Page 30 is the e-auction details,
Now
even.
give me the gist. What is the matter about?
Lordship. The matter what happened, there was an e-auction of scrap materials of respondent number 1 and 2. What happened that before the e-auction, one is required to deposit a particular pre-bid amount. It's a pre-bid amount, and I deposited a pre-bid amount of 34 lakhs. As per the auction notice, the EMD amount, pre-bid EMD amount, the EMD amount should be 10% of the total auction value. So I had deposited 34 lakhs with an intention that if I have to buy an auction, it will be in around 2 to 3 crores total amount of goods that I'll be buying. So e-auction happened on the day of e-auction. It was opened on at 11 a.m. So I entered into a thing. I entered a figure. The figure that I was intending to enter was 20,001. Mistakenly, I entered the figure 2,01,000. So at 4:30, when I came to know about it, I immediately informed the authorities. Now, short issue is the authorities have forfeited my EMD. So this is my short case. Now, when I came to know about that,
The order will also be very short here,
Lordship,
even shorter.
that is the facts of the case.
What can be done? You made a mistake. Mistakes are costly in this matter.
Lordship,
Where is the judgment? You have the judgment.
Patel Engineering, Lordship. That Lordship, may I,
Then there is a West Bengal Port Trust or something like that. There is a judgment.
Lordship, on the
Even a dot goes wrong.
Lordship,
it's over.
exactly on similar point, a division bench of Madras High Court dealt with exactly the same point, same facts, basically regarding the e-auction.
It
May I
is
place that judgment?
international bidding. It was open to parties from India and abroad, both.
No, Lordship, it's Indian only. Here also it is within India, so exactly the same point. May I place the judgment, Lordship?
What is the decision in this judgment?
They have, the Honorable Division Bench there has asked to refund back the EMD.
Okay, so you want a refund?
I want a refund of the EMD. Lordship, here, to the extent that whatever is the
But
cost
the
of
tender is over.
tender and the goods which were initially auctioned, that since they had asked me to deposit them, I did not deposit the money because I could not have deposited the money. It was re-auctioned, and that they have got the money also for that thing. So there is no per se any loss to the effect.
Yes, which paragraph?
Lordship, here paragraph the paragraph 16, Lordship. Lordship, the judgment may be read, so the whole judgment, because to bring in the parity of facts of Lordship, it starts at page 126. This instant intra-court appeal arises from order dated 18/9/2014 passed in WP 2907 of 2012. Pausing here, the petitioner there had approached the court, and the respondent herein was granted EMD along with interest. Against that order, the respondents went to the division bench. So this is the final order. Apart from this, they have not found any order in the Supreme Court. So that it is about this WPC. That order is also there, you know. The factual metrics leading to the filing of the writ petition is that in response of e-auction notice number such and such, the writ petitioner first respondent herein offered his bid to purchase of scraps. The second respondent was appointed as selling agent on behalf of the appellant herein, first respondent therein. The precondition of participation in the e-auction was to deposit a sum of rupees 5 lakhs as pre-bid earnest money deposit, exactly same like us, by way of demand draft on or before 12/9/2011, as the bid was to be opened on 13/9/2011. The writ petitioner made the highest offer to the tune of 1,24,22,002 rupees, and also deposited the requisite EMD amount before the specific date. The bid offered by the several other bidders ranges from 1,24,000 to 22,55,848. The writ petitioner, being the highest bidder, was informed by email dated such and such at 10:40 p.m. stating that his bid has been accepted provisionally subject to approval of the appellant for the bid of rupees 1,24,022,024 lakhs 22,000 rupees. He was further requested to make security deposit of an amount of 12,42,200 by way of BDPO in favor of the appellant within 7 days from the date of close of the auction as per the terms and conditions of the e-auction. It appears thereafter that a writ petitioner, instead of writing to the selling agent, wrote to the deputy registrar of the appellant on 13/9/2011, informing that the first respondent writ petitioner had wrongly quoted the figure as 1,22,42,002 rupees instead of 12 lakhs for 24,202. Lordship, pausing here, I have directly written to the email to respondent number 4 that I have wrongly given the bid amount. And as such, a request was made to refund the EMD amount of 5 lakhs. An identical communication was sent to the selling agent, that is the second respondent, on 14/9/2011, treating the aforesaid letters as a revocation of offer. The pre-bid EMD was encashed and sent to the appellant by selling agent by communication dated 19/9/2011. It was confirmed subsequently by the electronic communication dated 22/9/2011. Being aggrieved of forfeiture of the EMD, the writ petitioner made several representations for refund of the EMD amount. By communication dated 25/10/2012, the writ petitioner was informed that his offer to the tune of 1,24,22,002 rupees was accepted, and he was requested to deposit the security deposit within 7 days from the date of close of such said auction. And as such, he failed to comply with the same, exercising power under the terms and conditions of the auction. The pre-bid EMD was forfeited. There against, the writ petitioner has come up with the instant writ petition questioning the legality of the communication dated 25/10/2012, and further a direction to the appellant herein first respondent and the second respondent therein to refund the EMD amount of rupees 5 lakhs with interest at the rate of 12% per annum. In the writ petition, the writ petitioner raised the contention that the offer of 1,24,022 lakhs 2 rupees was typographical mistake, which was corrected immediately before the opening of the tender, and as such the appellant as well as the second respondent were informed well in advance to cancel the offer of the writ petitioner. To that effect, a letter was sent on 13/9/2011 and also on 14/9/2011 seeking refund of pre-bid amount. Thus, the appellant and the second respondent herein were not entitled to forfeit the said amount. Secondly, the writ petitioner was communicated about the forfeiture of the pre-bid amount only on 25/10/2012. Thus, the writ petitioner is entitled to interest thereon. The learned writ court, considering the issue of non-mentioning of upset price in the e-auction notice, held that the respondents have not followed the mandatory procedure, and as such the same was not legal and proper. It was also held that the acceptance of the petitioner's bid was only provisional, subject to the confirmation by the first respondent, and therefore the stage of forfeiture of EMD amount has not reached. It was held that since the sale was not confirmed, the forfeiture of the EMD amount was unsustainable in the eye of law. Accordingly, the writ petition was allowed with a direction to refund the forfeited EMD amount with 9% interest per annum. Mr. Kartik, learned counsel appearing for the appellant, would submit before us that the learned judge has considered the issue of non-mentioning of upset price without there being any pleading by the writ petitioner in the writ petition. The issue was considered at hearing stage as the petitioner has not questioned the legality of the forfeiture of the pre-bid EMD on account of the fact that the e-auction proceeding itself was vitiated as no reserve price was mentioned in the e-auction. It is further contended that since the writ petitioner had accepted the terms and conditions and offered the highest amount of 1,24,22,002 rupees, which was also accepted, the issue of non-mentioning of the upset price without there being any pleading cannot be permitted to argue and consider. It is further urged that the writ petitioner has failed to
Right, I've seen it.
Lordship, here, what had happened? Lordship may.
Where is the order forfeiting the EMD?
It's an email, Lordship.
Where is it? Page 45.
Page 45, Lordship. Page 45, I was asked to deposit, Lordship. Page 47 is the email, annexure 8. Lordship, for a moment, if Lordship,
Yes, come to the next, what is it? Next,
next.
so this amount has been forfeited by the MSTC portal or
MSTC portal,
not the power grid?
not the, because MSTC is the person, is the authority who took the amount.
Who is appearing for the MSTC?
Lordship,
Yes. Why aren't you returning? If he has quoted a wrong amount, why should you forfeit it?
That tendering process, not like this other e-auction lottery.
Ah,
Once it got registered lordship, all the tendering process was stopped there only. And
no, no, is there any clause which allows you to forfeit it?
That's in the tender itself, my lord.
Where is it? Which page?
That is.
page 30. Lordship, to that effect, I will, page 30 is the tender.
Page 30.
Page 30 is the tender notice, and regarding EMD,
Hmm. Regarding EMD,
page 33. First, second, it should be noted, the para starting from, it should be noted, the third line, in case of failure to pay EMD for pre-bid EMD lots within stipulated payment, such pre-bid EMD will be forfeited and user account of the buyer
Will not be
will not be deactivated.
Deactivated.
so your client had not deposited the amount of EMD.
No, Lordship, what happens is that in the bidding process, you are first required to deposit money in a wallet, which is known as a pre-EMD wallet. That was there. Once it was settled in my favor, even after my mail, the authorities took the amount from the pre-EMD wallet and treated it to be as an EMD. So they took that as EMD amount and they forfeited it. Lordship, to this effect, I just want to place one part that here in this tender notice, Lordship, may please be page 31, just for page 30, I just want to show the first part, page 30. Page 30 is the heading, event number, opening date and closing date. Lordship has got it. It is saying opening date is 21/2/22, time is 11 to 11 AM. And the closing is 21/2/22 and the time is 14:30. I have
16:30.
I'm sorry, Lordship, 4:30. So 4:30, I had given the mail. Lordship, here, after I had approached this court and they wanted to sell the auction, they again went through the auction process. In the auction process, this was retendered. Now I want to just show one point. Lordship may be pleased to take the additional affidavit which I had filed, Lordship. And it starts additional affidavit that I had filed. Same an auction notice was given. In that auction notice, the starting time was given as 11 and the closing time was given at 3:30.
Mr. Das, the court appreciates that you must have made a lot of preparation. But you see, it is not important that you should say whatever you have prepared.
No, Lordship.
What is important is you must tell the court what the court wants to know.
Yes, Lordship.
At the moment, I am only asking a question. Is there any clause in the tender dealing with forfeiture of EMD?
That
Show me
part-
that.
That's a Lordship.
That's
I
it.
saw page
Show me
30
that. If I
page
want
30
any
page
further
33
clarification,
page 33, Lordship.
it's good to be prepared, but you reveal it when the court wants to.
Extremely sorry, Lordship.
Otherwise, there is no need for me to go to everything.
But-
Where is the clause? Page 33.
Page 33, second paragraph.
Please read it.
In case of failure to pay EMD for pre-bid EMD lots within stipulated per such pre-bid EMD will be forfeited. And the user account of buyers will not be deactivated.
So is it a case where there has been failure to pay EMD?
Yes, Lordship, because the EMD amount for, if I had quoted, my quoting amount was 20,000, mistakenly quoted 2 lakhs. So my EMD amount is somewhere around 2 crores. I have deposited in the pre-EMD 34 lakhs. They had taken the 34 lakhs and that is forfeited.
34 lakhs is gone.
Gone. Now it's forfeited. It is subject to the outcome of this petition. So that's why, sir, Your Honor, your Lordship, what I wanted to show is that the next process which they initiated, their contention is that there is some loss to it. At 4:30, I said that it is a mistake on my part. So in the next process they initiated, it is their tender notice which says that by 3:30 it will close, but their tender closed at 9:20 in the night. So at that relevant point of time, when they came to know that yes, he has wrongly quoted, they could have opened it and the render process would have restarted. It would have restarted and they could have closed at a later date, which they did in the next tender. So my mistake was that I gave, instead of 20,000, I gave 2 lakh. That is a mistake, to which I have already said that I am ready to pay for the addition, the next auction notice which was done. Whatever was the cost, I am ready to pay via that cost. That loss may not be given to the state. I have even told.
But you agree that you come within the teeth of this clause in the tender.
No, Lordship. I'm not agreeing. Lordship had asked me under what they have, this is the thing which is there. So this is not complete, because 4:30 I have given a mail saying that I am not giving this offer. I have withdrawn my offer.
Okay, now let us go through the documents. Show me the documents. What are they?
Lordship, page.
Just 1 second. All right, now where is your email saying that you are rescinding the offer?
Page 41. There are 4 emails, starts from page 41. At 4:30 PM to MSTC, respondent number 4. I have also written to the respondent number 1 and 2, page 43. Page 44 also is an email which I again wrote to MSTC.
So you have made some payment on 22nd of February at 3:20 PM, page 48. Thank you for your payment as per details. What is this 34 lakhs
This is my pre-EMD amount, which they have taken, which is
taken from
like
the wallet?
from the wallet. They have taken 34 lakhs. So as per the tender notice, I was required to give the requisite, the remaining balance amount. Since if I had quoted the right amount, so 34 lakhs, if 34 lakhs is the amount, my idea would be always to 10% of the amount. 10% would be around 3 crores would be the amount that I would have been purchased. So mistakenly, now the EMD amount becomes 2 crores 72 lakhs. So they have taken the amount, 34 lakhs, they have taken the EMD amount. This is the point that they are saying there. Thank you. 34 lakhs, 49,000.
All right, anything else?
Lordship, regarding I'm reiterating that part. Regarding the auction notice, the respondents are saying there is a loss because other bidders could not have participated, because as per the bidding process, once I give 2 lakhs, anyone who has to participate has to give more than that. So admittedly, since I gave 2 lakhs, 2 lakhs per metric ton, then no one would have given above that. That's why it stopped there, which I admit, which there is no denial. But at that relevant point of time, when they got the email, they could have released it, okay, this is cancelled, and more bids would have come. Had it been a case where they had not cancelled it and there was no bids were coming, that is not the case. Because in the next subsequent bid, the bid was settled at evening at around 9 o'clock it was settled, which is as per the record. It is not a case that even if the time is given as 3:30, that 3:30 it closes. Since it's an auction process, it's a continuous process. Auctions keeps on coming and it can be extended. So there was no loss to it. I had given, it is a mistake, which I admit. And for that part, for the loss may not be caused to the respondents, is regarding the loss of advertisement, which was the cost that is incurred while making the advertisement and the tender process. That I'm willing to pay. But 34 lakhs EMD may be refunded minus the advertisement cost.
What is the advertisement cost?
That they have to tell. I have no idea. Because I am not the authority.
If they say it is 34 lakhs, then what will you do?
If it is supported by papers, I'm bound to give. If they can show it that an advertisement cost is 34 lakhs, then I'm bound to give. They will support it by papers. It's a government organization, it will be audited. It's not that they can say any price they want to say. This is my respectful submission regarding that. And they have, this is the only aspect. It's a mistake, bona fide mistake, which I rectified the moment I came to know. Since I had to look into the board, when I saw that it was not moving up, I don't know what happened there. And one aspect also has been taken contention of the respondent they have taken is that you get an opportunity twice to fill that amount. To that effect, I would like to submit, Lordship. First, I give in figures. Then once I give in figures, the system takes it at words. Then there are pop-up comes. In the pop-up, you are not required to re-enter the figure. You just need to confirm. So it's an optical illusion kind of thing, which happened when I looked at it, the mind was reading as 20,001 only. And all the other bids before 20, it is not a case where earlier first bid was, I think, something around for 1400 or something. My bid was all other bids before that, the highest bid was 17,000. So my mind was always at that it was 20,000 only. My bid was since it was 17,000, I would have bidded for
And in
20.
the subsequent bid, it was, what was the price by in which they have settled
It is 1,700, 1,70,000
per metric ton?
per metric. They have settled, the subsequent it is 1,70,000. Since there is no reserve price to that effect, there cannot be any loss to that effect, so it's a scrap material. There was no fixed material that this was the price. And my bidding amount, which I had given 20, because the last bidding amount before me was 17,000 something, which is 17,000. So I gave 20,000, thinking in my mind it was 20,000, but while I typed, and it is 20,001. So the zeros got mixed up that way. So that is my case. So this is what has happened. So the
Costly mistake.
costly, it's a costly mistake. Now, Lordship, I pray that it's a mistake to the effect where 34 lakhs is now at stake. So whether any loss has been incurred to them because they have sold that material, and that 34 lakhs, which is there, which was a EMD amount, they have got the amount, there is no as such, there is no loss. The only loss that they have incurred probably is the advertisement cost and the re-auction, which cannot be by any rational thing with 34 lakhs. It will be somewhere around whatever is the amount they say. Subject,
According to you, what is the amount?
probably 10, 15,000. It's an e-auction. It's an e-auction cent. No cost would be in there. It's already the system is there. It's an e-auction. There's no cost effect because the system is already there. So it should not exceed 10 to 15. I don't know, Lordship, subject to whatever it is. That I don't know. This is my personal. Since it's an e-auction, there is no cost effect. There will be no material cost, nothing as such. You don't need to publish in a newspaper. It is.
And you say that the closing time was not 4:30, but late in the evening.
No, this is for the subsequent bid. What I submit, Lordship, is that they say that there is a loss to it because other bidders could not have participated. To that I submit, Lordship, at 4:30 when they came to know, 4:30 they came to know that I gave a wrong thing because email was given. These are all online and they have access to all these things because the bid process was going on. They came to know that yes, he has given wrong. They could have rejected the bid, opened it, and some other persons could have come at that day. But they said, okay, fine, we got it. They were sitting over it. So they could have, that ground may not be a legally tenable ground. That's to that ground which they will.
There was only one bidder.
No, there were more bidders.
No. How many people had submitted the?
No, it's a e-auction thing. It continuously goes on. You type, one is required to give the amount. Like once I had given 20,001. Then someone will give 21,000. Then again, I'll give 22,000. Then they will give 23,000. This will go on now. It will go on. This is a continuous process. Their contention is that since I gave it 2 lakhs, others were not interested there, so it closed there. So my reply is that since it was no doubt it was closed there, but at 4:30 when I informed, they could have opened it. And they did the same thing with the other when they disposed of this material at a later date, which is there in my annexure to my additional affidavit, which it was closing time was given at 3:30, but it closed at 9 p.m. Means what can be understood is that it's a continuous process. Even if it is 3:30, it is 3:30. It is not a case. It is not their case. It is by documents. At 3:30, whichever came at the last bit, that was accepted. It went on. In the same thing, it would have gone in the process. So this is my submission.
Yes.
May I please, your Lordship? Before that, my lord, I will place before your Lordship my annexure 2, my lord, to my affidavit of opposition, my lord. At page 24. Before entering into the system, my lord, the bid amount quoted by the petitioner is confirmed, my lord. And after confirmation only, my lord, this bid amount was entered in the system, my lord. Once my figure is entered in the system, there cannot be any change, my lord. The party cannot withdraw. There is a present system, my lord, in e-auction, my lord.
Once it is confirmed, there is no question.
No question, my lord. That is that he himself got confirmed about the bid amount who he has entered in the process, my lord, e-auction, my lord. After confirmation, it was entered like that. For that, I will place you before Lordship annexure 2, page 24, to my affidavit, my lord.
Just 1 minute. Yes. Yes, please.
This is a letter addressed to the retribution, my lord, pursuant to his letter by which he has informed to cancel his this bidding on my lord. This MST auction by portal provides a completely automated, transparent, and unbiased platform to the bidders to compete for buying auction items. Hence, it is the utmost responsibility of the bidder to be extremely cautious and sincere while bidding. Moreover, when a bidder quotes the amount, an auto top-up generated by system asks the bidder to reconfirm the quotation amount. Given all these factors, it is irrelevant whether the bidding was done erroneously, intentionally, or unintentionally. And once the bid is registered in the system, it will be treated as an established fact that the bidder is ready to pay that quoted amount. Therefore, no such request can be considered in this case. Pre-bid AMD will be forfeited as per auction terms and conditions. When he himself has confirmed, my lord, before entering into this system, my lord, he himself has confirmed about the figure, my lord. This was not mistake, erroneous mistake. If intentionally he has put the figure, my lord, just to stop the other bidders to compete, my lord. At the last moment, he has offered this bid amount, my lord. And now, my lord, in the my lord, actual reaction, my lord, that in the additional affidavit we have filed, my lord, yesterday, my lord, you have said how much the corporation is going to suffer, my lord, because of his mistake, my lord.
No, that is another thing.
My lord.
We'll see if the action is in terms of the clause.
Clause, my
We'll
lord.
dismiss the writ
My
petition.
lord,
We're not concerned. These are commercial matters.
my lord.
If the action fits into the clause in the contract,
My lord.
we'll dismiss it. If it doesn't, we'll allow it.
So that is back the terms and
That's all we're trying to
all-
understand.
all replaced by
We
my
don't want to know what went behind it,
my lord.
what was his idea, these are not the
My
ways.
lord.
These are commercial matters.
Right.
So parties will have to bear the brunt if they make a mistake. So you are saying that the amount initially entered by him
My lord.
was subsequently confirmed,
Confirm, my lord.
and that is when it got locked,
My lord.
right?
My lord.
After that, even if he informs that there was a mistake,
Hmm.
nothing can be done.
That can.
So what is the basis of saying that? Is there any clause in the contract or tender which addresses this issue?
No, my lord, that was
You are referring to the counter affidavit filed by respondent numbers 1 and 2,
my lord.
1, 2, and 3,
1, 2, and 3, my lord.
dated 21st of August 2023.
Correct, my lord.
Which page you want to refer to?
No. Uh-huh. Page 21, my lord, of my affidavit.
Actually, there is no page number in your affidavit.
No.
There is
No,
page
the
number.
affidavit, that is initially, the affidavit which was filed initially, my lord.
Affidavit which was filed initially. All right. That is which was filed on 22nd of June.
You mind.
All right. Page number?
Page number, sorry. Page number 21, my lord. The medium,
Yes,
from the bottom, my lord, it will be 1, 2, 3, 4, fifth paragraph, my lord. It should be noted that failure to submit PMD within above a stipulated time, all will result in automatic deactivation of the buyers of the logging from MSTC system for a minimum period of 6 months. That the bidders shall be debarred from participation in any such auction being conducted by the MSTC for a minimum period of 3 years. In case of failure to pay EMD for pre-bid EMD loss within the stipulated period, such EMD will be forfeited. As soon as his bid is accepted, my lord, he is supposed to deposit the balance amount, my lord, EMD. That was not done because for that, this is the amount
So
already.
his EMD total would have been about 2 crore
My
72
lord, my
lakhs
lord,
something.
as per his.
So only
bid amount.
34 lakhs was there in the wallet.
My lord,
Remaining amount he did not deposit.
didn't have deposit, my lord.
So that 34 lakhs was shifted from the wallet to the
My lord,
bid account,
my lord,
EMD account.
my lord,
But due to non-payment of the balance,
Well.
it was forfeited.
appropriate,
And you say that he had reconfirmed the amount.
my lord,
There was no question of any mistake.
my lord.
And he says that I intimated them at 4:30 that there is, the amount is quoted by mistake.
My lord.
But in that letter, I don't find any request to cancel his bid.
No, no, my lord.
That is not there. He only says, I made a mistake.
My lord.
That's all, is it not?
Not that.
Lordship, the language is.
No,
No,
no.
doubt.
No, no,
That's
that's all right.
that's-
We
yes,
will have to go by
Yes,
the
yes, yes.
record, what
Yes,
is
sir.
there.
Yes, Lordship.
What
It-
was there in his mind, we don't know.
Yes.
We'll have to go by the record.
But the
Maybe
last,
that it was a tactical ploy.
My lord,
It may not be that. But then he's a businessman who's been in this. Is this his first bidding?
no, no, Lordship. It's not his first meeting, there is no, it's not his first.
So he
It-
knows how this whole thing operates. He knows that after he confirmed the price, he knew that there is no question of wriggling out.
No, Lordship, he knew that the confirmation part which my senior friend, senior counsel is saying, that part is there because the confirmation is only, you have to click, you don't have to re-enter. There are two confirmation can be done in two things. We are like, first we enter an amount, we re-enter an amount. When
Mr. Das. Taking it beyond that would, then you have to lead evidence. What was in his mind, who was with him?
No,
Because
that-
we can't go, if you go by the documents, then he reconfirmed that it was 2,01,000. He reconfirmed it. And at 4:30, he wrote a letter that the figure was mistakenly quoted. That's
And-
all.
he wrote a letter at 4:30 saying, and it is for his consideration. The last part may be read, which should maybe understood in a way that he asked for reconsideration of it. The last line is saying that if the letter is read into it. This is for information and necessary consideration, please.
Mr. Das, difficult matter. Let us admit it and put it to hearing.
Gotcha.
This is come for
I
admission.
give it to you, lordship, my lord.
This level of effort will not take you anywhere. Anyways, there is no hurry for you.
No, my lord.
All right. Heard Mr. Arjit Das, learned counsel for the writ petitioner. This is not a matter which can be summarily decided. I don't think you have a good case.
My lord, full length hearing will be nice, my lord.
Yes, yes. Because these are
No,
international
no.
tenders.
Not
I
that
mean,
point,
these are-
lordship, your lordship has already referred, my lord,
Here-
about that.
You make a mistake, you make a mistake. You
Mistake.
have to pay the price. That's all.
Yes, Lordship, that
There is
is,
no remedy for mistakes.
Well,
You
but-
get a one chance, anything in, let's assume there are electronic fund transfers, right? If it happens by mistake in the first shot, understandable. Once it is reconfirmed and the money is gone, it's gone forever. That's how e-matters are. It cannot be reversed. The principle is not done.
Lordship, in electronic fund transfer, what happens is when we add an account or anything.
You have OTP.
No, Lordship, before an OTP, we are asked to enter the account number twice. It is once we enter the account number, the second is account number twice. So if a person, when it happened, that's a mistake which can be rectified. Here, if it was 22 lakhs, twice if he has entered 2 lakhs, then
No, but you have reconfirmed it.
the reconfirmation is to the, the reconfirmation, one has to understand how the reconfirmation was. It was to the effect, if the pop-up comes, the pop-up comes, here you look, the figure.
Then in your letter, you don't say all these things. You just say, I made a mistake.
No, Lordship, the reconfirm, the letter at that relevant point, other letters I have written, it's a mistake, you reconsider the EMD may be refunded. That in the same day, I had given the letter. Now, what, Lordship, what I had written in the letter was at that, when I came to know, I immediately shot a mail. And it was short at 4:30 because I thought it's already 4:30. This was a mail just to intimate.
Now, how did you come to know at 4:30?
That's lordship. That's what it. What had happened is that after I had given the amount, I have given the amount. So for 20,000, I gave the amount.
At what time did you reconfirm it? Where is the pleadings to that effect? Show me your pleading. At what time you detected the mistake? When did you reconfirm? When did you detect the mistake? Where are the pleadings? Then you have to make out a very strong case on facts. Some vague pleading will not do, Mr. Das. See, these are commercial matters. you have to
Paragraph
understand.
6.
Huh?
Paragraph 6, I have given the
Please read it.
that it is stated that the tender auction was to open at 21/2/22 at 11 AM and close on the same date at 4:30 PM. The petitioner bid for lot 1, but there was a typographical error in typing out the data field in respect of price offered per metric ton. As such, the bid value offered by the petitioner read as 2 lakhs instead of the intended 20,000, which was their desire to offer. The error was seen just in time by the petitioner and he transmitted an email to
No,
email
no,
on
Mr.
such
Das, Mr. Das.
at
see,
exactly 4:30.
See, this is your story. This is your story. This is the story you are giving.
Lordship.
The court wants the fact. What time did you put in the figure? What time did it pop up? What time did you reconfirm? What time did you notice that there was a mistake? Where are these pleadings?
The time, exact time when the exact time is given, it's in the affidavit.
You are saying you made a mistake.
Yes, sir.
So the court, this is your version. They are saying it is not a mistake. The court has to give a finding that it was a mistake. Where is the pleading? Where are the basis to come to that conclusion? You want that finding to be given by a writ court. The only way we can do it is if we have the pleadings on record which are either controverted, uncontroverted. Nothing is there. You just give a story. I came and I did this. You see, I forgot and then this happened.
No,
You will
Lordship.
say you did it deliberately. How is this writ court supposed to give a finding on that?
Lordship, the writ court obviously would not be able to give a finding on facts that I admit, but
You have to be conscious that the level of effort, pleading, contest in a commercial matter like this will not be the same in the matter of compassionate appointment.
Lordship.
You can't come with same approach in both these matters. Here it is a tooth and nail fight. Tooth and nail fight. You are saying it was a bona fide mistake.
Lordship.
The moment I realized the mistake, I took rearguard action and there was enough time for them to address the issue I raised. Where is the factual foundation to come to that finding? You have just given your story. We want facts. Where are the facts?
Lordship, page 16, I'm sorry.
What time did you reconfirm the sale? The amount? With that, if that figure is not there,
No, time
try
I,
it somewhere else. This court cannot get into this. You have to give the time. That's why pleading the very
time
important.
4:30, the moment I came to know, I gave a mail.
No, where is your statement that 4:30 you reconfirmed? You have to come up with your pleading, then we'll ask call for the records.
13, page 39, the error was seen just in time by the petitioner and he transmitted an email.
All right. You have done your bit. Let it go for a usual hearing.
Lordship, it may be in admission stage only any other day that I pray because 34 lakhs is there. It has been debited from my CC account and I am being paying the.
You'll have to.
Let it be in admin stage till I pray that much.
Before another court.
If-
But I'm not happy with the level of pleadings in these matters. These are very vague pleadings, casually done pleadings. I'm sorry to say that. In a matter like this, when you are asking the court to reverse a payment deducted to the tune of several lakhs, just giving a vague story that you see, I filled up, I submitted, I made a mistake, I told them. Oh, what kind of pleading is this? You have to give every minute details. If they don't controvert or they controvert, we'll ask for the records. You have missed the bus on that. Try your luck.
I'll be careful for.
No, no, nothing too personal to you.
No, Lordship, that's
Talking
my
about the
mistake. That's my mistake.
No, my lord, the Supreme Court, your lordship referred, my lord, that to 2001 to SCC, my lord. There is
Yes.
West Bengal State Electricity Board,
But-
by Petrol Engineering, my lord.
Point number 3, I feel I am covered by point number 3 of Patel Engineering. That is my service.
No, but your case is worse than West Bengal and petrol engineering.
No,
Your
the
case
point-
is worse because I'll tell you why. Whatever, it's your client's luck, whether he ultimately gets relief from whichever court. There is a saying that every case can be won. It all depends on what is the level of effort. But leave that aside. The crucial factors here are that the public sector enterprises, they are entitled to maintain a very strict norms for carrying out tenders. If they don't do it, they will suffer the wrath of the CAG and audit besides other things. So if they have taken any action which has had an adverse consequence and you are approaching the writ court, the court will exercise a power of judicial review, see whether their action is in accordance with the laid down norms and condition of the tender or not. The court cannot go into stories.
No.
Let us assume that in some cases stories will have to be looked into. Then also you have to give the pleadings. The facts have to be absolutely crystal clear. Here the whole issue is about you put in a figure, you confirmed it, then you thought it was a mistake, you withdraw it. These 4 important events, the exact timing, etc., were required. You have carefully hidden all these things. You have just not disclosed anything about that. You did not say when did you put the figure, how did you put it. You did not say when the pop-up came. You did not say when you confirmed it, how you confirmed it. You did not say when you realized the mistake. And you just start that I put in a figure and I realized a mistake, I wrote to them. The facts in between are missing, which would obviously give an impression to the court that these are all tactical stand. You realize that for some reason it's not working out. It could be that you had an end-to-end tie-up with someone to buy it for 3 lakhs. Didn't work out. So you want to withdraw. Before that, you wanted to block everyone. All kinds of possibilities are there. We can't speculate on these things. Mr. Arjun Dasnani, counsel for the petitioner, also heard Mr. M.C. Dasnani, senior counsel assisted by Ms. N. Devi, learned counsel appearing for the respondent numbers 1, 2, and 3. Ms. P. Das, P. Boro. You have not appeared for long, so part of your name has got deleted. Ms. P. Boro, learned counsel, has appeared for respondent number 4. On the request of the petitioner's counsel, let this matter be listed for admission hearing again after 4 weeks. Yes.
Published.
Put in some effort. Better preparation. This will not work out.
17.
May I pray? In this case, respondent number 1 to 4 has filed affidavit in opposition on 19th. Just settled. I pray for 2 weeks' time to file a reply.
Who has filed affidavit of opposition?
NHIDCL
Respond number?
1 to 4. And I'm told
Mr. A. Bhattacharya, learned counsel for the petitioner, submits that a copy of the counter affidavit filed by respondent numbers 1 to 4 has been served upon him only a week
Yesterday.
back, only yesterday. And therefore he will be given 2 weeks' time to seek instruction and file rejoinder if deemed necessary. The prayer is not opposed by Mr.
My lord, I am appearing for respondent number 8.
None has appeared for the respondent numbers 1 to 4 to oppose the prayer. Mr.
SK Deori.
SK Deori, learned counsel for the respondent number 8 is present. What do you have to say?
Yeah, my lord, I am filing my affidavit today only, my lord.
And he submits that affidavit on behalf of his client will be filed during the course of the day. In view of the above, and on the request of petitioner's counsel, let this matter be listed again after 4 weeks.
2 weeks.
No,
Oh,
after
my-
3 weeks. You want 2 weeks time and then the very 2 weeks you want the matter to be listed.
No,
What
no,
is-
no.
What is the
This
case
my-
about?
This is my burden to file. Therefore, I'm
Or maybe the
taking less
registry
time.
will need time to tag it with the record. 4 weeks. The parties may exchange pleadings within 3 weeks from today.
like
Apply, sir.
maybe continue. Interim order may continue.
Interim order passed earlier to continue.
Obliged.
Check it once, please.
18.
Maybe. Lordship. 1. No. Maybe, Lordship. As per order dated 2/8/23, my lord, they file affidavit saying that they resubmitted the bill to the government, my lord. It is a primary stage, my lord.
What council's fee?
Not
Lordship,
council
yes,
fee, your lordship.
What is the amount?
9.46 lakhs, your lordship. So the proposal has been forwarded, your lordship, from the RCS office, your lordship. So now financial concurrence will be required, your lordship.
Finance is the main part.
Lordship, here the proposal and we said, Lordship, may grant us some time, Lordship, I'll find the exact status as to the status of the proposal that has been sent by Lordship.
It's a affidavit in
So it
opposition,
seems the council is in some difficulty.
lordship.
The person,
Yes, there's some
A
urgency.
short date may be fixed, Lordship. I'll just find out as to the status. But
Mr. A.K. Azad, learned counsel for the petitioner, has invited the attention of this court to the affidavit dated 21/8/2023 filed by the respondent number 3 to submit that although the bill of the petitioner appears to have been forwarded to the finance department for concurrence, yet in view of the critical health condition faced by the petitioner, the matter requires to be expedited, as otherwise the same would lead to grave injury to the interest of the petitioner. Full stop. Mr. Rajkumar Lanet. Mr.
Corporation Department, your lordship.
V. Rajkumar Lanet, Standing Council Corporation Department, Assam submits that unless the sanction of the government is received, unless the financial concurrence of the government is received, the amount cannot be received. At this stage, Mr. H. Alia Lanet, HC Finance, seeks posting of this matter after 2 weeks, so as to enable him to obtain instruction and appraise this court as to whether the bills of the petitioner can be fast-tracked, keeping in mind his critical health condition. A copy of this order will be furnished to Mr. Chalia during the course of the day. List again after 2 weeks.
Can I date?
Obliged, your lordship.
Yes.
For hearing, I can tell.
This matter would skip Pathad. On one occasion, my lordship was of the view that the petitioners had a case and therefore perhaps the termination order should go, but with the long lapse of time and the allegation that was on him of having consumed alcohol and the long lapse of time till now, lordship had expressed a view that he should perhaps be allowed to go on compulsory retirement from the date on which the writ petition is disposed of. On that view, my lord, we were to have a discussion of as to what would be the benefits. Now, respondents have now, in the meantime, there was also an instruction that we should provide our bank details so that they can deposit the whatever money has been accumulated till now can be deposited to us because we had not drawn anything. I am told today that they have made a deposit of around 17 lakhs to the petitioner. Difficulty is, my lord, when I had a discussion with the petitioner today, he says that some 9 lakhs has been deposited in his 9 lakh or has been deposited in his account and another around 8 to 9 lakhs have been deducted, saying that he was occupying the quarter, official quarter, and therefore they have deducted all the house rent from that account itself. My lord, therefore, decision on the writ petition would now be perhaps be required to be taken if the termination was wrong and he's given the notional continuity in service, allowing him to retire from now. Then, my lord, all the deductions they're making from him would come back to him notionally, which they cannot deduct them because he'll be entitled to HRE if he was notionally in service. Those part will come in.
But unless you
Final-
challenge that,
Which part, my lord?
that part, the reduction
My
part,
lord, that deduction is only coming now during pendency of the repetition because it had fallen from lordship that let them pay whatever was accumulated to me. The final decision then in the repetition
so
can be
that
taken.
you are accepting, the deduction is correct.
Yes.
That you are accepting.
If the termination order goes and if I'm given the continuity in service, they cannot deduct anything from me. That would be something that they're doing now whimsically because an option was given whether we can have a settlement on that issue. But that they have not agreed to. So now finally, my lord, there has to be an order from the court to say that the notional continuity has to be there. Otherwise, he does not get anything with this 12 to 14 years of
Yes.
litigation.
My lord, with the consent of both party, we have come into conclusion, my lord. But because of both are sitting together, my lord, what will be the amount, my lord? That as per my instruction, my lord, amount has been paid to the petitioner. But what deduction have been made, I don't have any instruction, my lord. I'll place before the court what the deduction they have made, my lord. Within 2-3 days, my lord, then court may pass in.
Is that
If any deduction have been made, my lord, in
what? If it had been continuity in service and if I was in service till the date of disposal of the repetition, the entire amount has to be calculated. And thereafter, I
No,
have to be paid
retirement-
whatever was there on my retirement, then notionally I would have gotten all the benefits. What they have done is, from the date that I had actually retired, till then, from then till now, whatever was accumulated as taking retirement from that date, they have
So
decided.
there is a recent judgment of this court.
Yes, my lord, Naresh Chandra.
Notionally,
Yes, notionally there is.
where is the judgment? Let's
That's
see.
judgment I have.
Ms. Gahan, have you read the judgment?
That part, my lord, perhaps has been taken up in appeal. That part has been taken up in appeal. But here I am consenting to that. part.
You are the counsel in this.
No, my lord, Mr. Weissman was the counsel. I had assisted only on that part, that review, if revision can it be done after the time lapse. There I had assisted the court only on that part.
So there is a appeal pending as the judgment.
Yes, there's no stay or anything. I was
No,
in the
that's
court
all
that
right.
day when it was just taken up. Because they do not consent to that part only, that compulsory retire from today, that he should not be allowed to continue in service, that they have made an appeal from the submissions what I had heard. In the appeal, they have simply said that we should have been allowed to continue in service. But in this particular case, my lord, I am consenting to the consent, compulsory retirement. On day one, I had consented. Because he will not be able to go back.
retirement has been calculated.
So that was my first submission on the earlier day. Even if he is now allowed to go back, I do not know what physical or medical.
No, I very scantly remember the facts.
It is reflected in lordship's order
Yes, my lord.
that it will not be proper to go back. That he-
Maybe subject to, of course, we have to conclude the hearing.
Yes, sir.
The court may consider passing an order for notional continuance till the date of retirement without reinstatement.
Yes, ma'am.
So in that event, so you therefore place it before the court.
Yes, ma'am.
On what account, how much amount has
Yes,
been,
ma'am. I'll place, my lord.
where is the order you give it?
Yes, my lord.
If
And that has to be a part of the record.
Yes.
Yes, ma'am.
Yes.
Once that is produced, you have to probably file an additional
Yes,
affidavit. Then we'll see. Reinstatement is something
I'm
we
not
should
praying,
not expect.
in this case, I'm not praying for that because
But we'll see if the charges don't appear to have been established in a legitimate manner. Then we'll have to mold a relief. We'll have to see, because some tests were not done properly.
that
etc.,
was one
etc.
aspect, my lord. Every witness had stated that he was smelling of betel nut,
Little-
while their allegation was that it was alcohol. No tests were done. I had produced a division bench
Yes.
judgment and the Supreme Court judgment saying that the test was
Test
required.
was done, but my lord, not that the blood test was
So
not.
all
done.
right, the
Mhm.
point is, he is not coming back to service.
Yes, my
That
lord.
you can be sure.
Yes, my lord.
But if the court is convinced that the entire process is not spick and span,
Yes, ma'am.
then the court may consider passing an order saying that he will be notionally in service till he attains the age of superannuation. What is the age of superannuation?
Well, 60.
He has already crossed that.
No. He has not crossed that, but he's ready to go on retirement at his request from the day the judgment is delivered. That much instructions I have.
But I'll place, my lord, whatever that the proportion has
That
been deducted.
also has to be brought on record in the form of an affidavit.
Yes, I'll do that. I'll do that. my lord. Let her bring on the calculations. In
Yes,
the
my lord.
meantime,
Heard Mr. R. Majumdar, learned counsel appearing for the writ petitioner, also heard Ms. A. Gayan, learned CGC appearing for the respondent. It is submitted at the bar that in terms of the order passed by this court on, what is the date of the order?
The last one of it.
my lord, 452003. 452003.
452023, the petitioner had met the departmental authorities, whereafter it was found that a sum of rupees 17 lakhs bracket approx was the amount due and payable to the petitioner under the original order of penalty dated
Original order of penalty.
2008. 27/7/2008.
14/9/2021.
Sorry,
14
4/1/2011, there was a revision.
4/1/2011. Mr. Majumdar, however, submits that out of the aforesaid amount, a sum of rupees 9 lakhs only has been deposited in the bank account of the petitioner. Full stop. Ms. Gayan, on the other hand, submits that at present, she does not have any written instruction indicating the amount that has been released in favor of the petitioner, and therefore 2 weeks time be granted for obtaining the said instruction and placing it before the court. Full stop. On the request of Ms. Gayan, this matter is therefore directed to be listed again for hearing after 2 weeks. So as to enable her to obtain. Let her obtain instruction,
Yes,
we'll see.
Must have.
We'll see what,
Yes.
in the legal framework, what can be worked out, which is not prejudicial to either party.
Publish.
Must have.
Hmm.
My lord, in this matter, technically it would be infructuous on their account, not the other way around. We have challenged an order of the APDCL had challenged an order passed by the ombudsman. It so happened that the TA states were drawing power at a lesser power than what they were connected load. So suppose X is a connected load, they were drawing less than X. So this incurred transmission losses. So we decided to levy 3% additional charge. This was the subject matter of challenge before the consumer authority. They affirmed in our favor. It went to the, they carried it to the ombudsman, and the ombudsman directed for refund. As against that refund, this writ petition was filed 2010, and there's an order of stay. Now, what my colleague had told me is that most of the TA estates have been sold, and so notwithstanding the stay order, even otherwise those amounts were adjusted with them. It's not my submission. Therefore, they do not have any claim so far as a refund is concerned. In that view of the matter, recording her stand, this may be, the order may be set aside and then closed.
My lord.
Otherwise, it will be a case of merits. But now, since they say that, she has not submitted, so she would, rather, that they do not have any further claim for additional 3% refund. It has been adjusted otherwise, and most of the tea gardens have been sold. Recording that submission, the order of the
So
ombudsman.
the ombudsman had directed refund.
Refund.
Yes, my lord. The operative part is at page number 55.
That is 13th of October 2010.
The order is dated 13/10/2010, my lord. Starts at page 46, annexure 9. The operative part is at page number 55. My lord, the line
Just
of,
1 minute, just 1 minute.
yes, my lord.
Yes.
My lord,
This
the
is an
line,
order passed by the
No,
the
no, no.
ombudsman.
operative part.
My lord, page 55. The paragraph after paragraph number 5, my lord, line starting with therefore. Therefore, the respondent distribution licensee, has my lord got it? Now APDCL is directed to refund the additional amount wrongly collected from the consumer tea estates of McLeod Russell India Limited in terms of the instructions by letter number so and so dated 23/2008 in the following manner. As prescribed in the ERC guidelines for redressal of consumer grievance. My lord, pursuant to this, my lord, the APDCL came in a writ petition and there was an order of stay insofar as this order is concerned, my lord, the order passed by the ombudsman. My lord, over the period of years, my lord, several adjustments were made insofar as the additional amount which was charged from the tea gardens.
These are all relatable to the tea gardens of McLeod Russell.
Yes, my lord. The respondent number 2, my lord. 2, my lord. My learned friend is appearing for the ombudsman. my lord.
What do you have nothing to say?
It was filed long back.
So several adjustments have been
Yes, my
made
lord.
and the petition respondent number 2 does not have any further
Any more
claim.
of refund, my lord.
So the order has been practically discharged
Yes, my lord, it has been
by
covered.
mutual
It
adjustments.
needs to be set aside, my lord.
Correct.
Otherwise, if the order remains on paper, then they're entitled to remand. Order is not claiming.
No, we'll note that
No
this
further-
does not have any other claim.
Yes, my lord.
So this order stands discharged. Why should we set
Yes,
aside?
my lord. Yes, ma'am.
The order stands discharged. All right, passing that order.
That's-
Heard Mr. S. Bunny, learned counsel appearing for the writ petitioners. Also heard Mr. A.K. Hazarika, A.J. Hazarika, learned counsel appearing for the respondent number one. Also, Ms. N.
N. Upadhyay.
Upadhyay, learned counsel is present on behalf of the respondent number two. Full stop. The judgment and order date, no, the order dated 13/10/2010 passed by the electricity ombudsman, that is the respondent number one, in connection with petition number 1/2010 filed by the respondent number two, is under challenge in this writ petition filed by the Assam, jointly filed by the Assam State Electricity Board as well as Assam Power Distribution Company Limited. Full stop. By the impugned order dated 13/10/2010, the respondent number one had directed the APDCL to refund additional amount wrongly collected from the consumer tea estates of the respondent number two in terms of the instruction issued by letter dated 23/12/2008. Full stop. Mr. Bonik, learned counsel for the petitioners, submits that during the pendency of this writ petition, some subsequent developments have taken place, as a result of which the respondent number two may not have any claim for refund at this point of time. Full stop. Supporting the above stand, Ms. Upadhyay, learned counsel for the respondent number two, has also submitted that after the order dated 13/10/2010 was passed, several adjustments of electricity tariff
Yes, my lord.
payable by the tea estates of the respondent number two has been made, as a result of which the claim for refund originally made by the respondent number two, as reflected in the order dated 13/10/2010 has since been obliterated and or wiped out. Therefore, the respondent number two is not seeking enforcement of the order dated 13/10/2010 insofar as the direction of
Refund,
the refund
refund.
made therein. Full stop. If that be so, it is apparent that by efflux of time and due to the subsequent adjustments carried out by and between the petitioners and the respondent number two with regard to the electricity tariff, the impugned order dated 13/10/2010 stood discharged. Full stop. As such, nothing further survives for adjudication in this writ petition. As such, with the consent of learned counsels for both the sides, this writ petition is being disposed of by providing that the order dated 13/10/2010 passed by the respondent number 10 will be deemed to have been duly discharged due to the subsequent adjustment between the parties, and the said order need not be implemented henceforth. Writ petition stands closed.
Obliged.
Obliged.
May it please yours. Sir, advance possession of various strips of petitioners' land were taken over by ONGC, pending withdrawal of appropriate proceeding either under the provisions of the Land Acquisition Act or under the provisions of Petroleum and Minerals Pipeline Right of User in Land Act. Now, my lord, what happened, my lord? In spite of lapse of considerable period of time when nothing has been done, and they wanted to acquire another plot of land measuring about 433 bighas. A meeting was held, my lord. Your lords will find at annexure 3, page 29. Look, this meeting was in respect of the another plot of land which was sought to be acquired under the PMP Act, measuring about 433 bighas. In this meeting itself, the point was raised at page 32, my lord.
Yeah.
Regarding the earlier land, my lord. Clause 2.6, my lord. RNT Plantation Limitation also submitted a copy of letter dated such and such regarding compensation for land measuring approximately 114 BA acquired by ONGs for laying of pipeline under ROU during 1970-88, for which payment is still outstanding. ADC observed that this is a separate matter, but however requested ONGC to examine the same and inform about the payment status. Thereafter, the once again by annexure 5, ADC wrote a letter to the ONGCL to sort out the matter, my lord. As RNT Plantation Limited is pressing hard for settlement of land compensation or about above land, you are requested kindly to look into the matter and take necessary in at the earliest.
That is page number?
That is page 34, my lord, annexure 5.
Yes.
Lord, in spite of that, nothing has been done. Thereafter, the petitioner preferred a read petition before this on record, and the order your lordship will find at annexure 7, page 52.
Page 52.
Page 52, annexure 7, page 52. This is the order passed by this honorable court, and the relevant portion concerning 114 bighas of land, your lordship will find at page 55.
Just 1 second.
6, subclause 1, my lord. The competent authority cum deputy commissioner Sibsagar shall make an inquiry as to whether the petitioner had been paid the amount of compensation in respect of 114 bighas of land, which was earlier acquired under the provisions of the Act. In such inquiry, the read petitioner as well as the respondent authorities shall produce the necessary papers enabling the competent authority to complete such inquiry and pass necessary order. In case any amount is found to be due and payable to the petitioner, the same shall be paid by the ONGCL by depositing the same with the competent authority cum deputy commissioner Sibsagar. This said exercise is directed to be completed within a period of 2 months from today. So, my lord, by virtue of this order, the competent authority is the collector. He is supposed to make an inquiry, and if something is found, then he has to make an assessment. And thereafter, he will have to direct the ONGC for deposit, and thereafter the amount has to be disbursed to us. But, my lord, nothing has been done here. A report was prepared. Your lordship will find the report at page 66. Page 66, annexure 12, my lord. Lord, if we go by the report, your lordship will find that some of the plots of land, the contention of the competent authority is that the lands were outright purchased. Whereas in the affidavit filed in the earlier case, my lord, by ONGC, which is part and parcel of this petition, the contention is that the pipelines were rerouted, meaning the lands were taken from the petitioner, but subsequently the pipelines were rerouted. So they were in possession of the land. So petitioner is entitled to compensation, my lord, in respect of uprooting of the crops as well as for the rental compensation. That has not been done. But as per the report, these were purchased, outright purchase, and the documents are in CBI. he failed to discharge the duty, my lord, that could have been verified from the revenue records, whether the names were mutated or not. Now, as far as certain plots of land are concerned, my lord, I have prepared a chart. I will forward you, submit the same before your lordship, my lord. In respect of certain plots of land, that is, your lordship will find at serial number 15A, page.
Mr. Kejriwal, first tell me one thing. You want just an order or you want effective relief for your client?
In order
Be very
for it,
clear.
my lord,
Only an order,
in order.
like the orders that have been coming. Similar to that, we can see, please understand. Just an order, brushing things and putting it into a track is one thing. Another thing is to have some effective steps on the ground. You will be obviously asking for the second one or the first one. You have already got the first one.
Yes, my lord, he has.
It
to
has
take
not
the-
happened
yes,
anything.
No,
You want something like
Yes,
that again?
yes.
You
No.
wanted that again?
No.
Because there is an order of the court, you have not filed any contempt. Technically, your petition is barred. I hope you are aware
My
of.
lord, because of the preparation of the report, subsequent cause of action has arisen, my lord. And for implementation, I can file, my lord, there are judgments, your lordship is aware, my lord, that for implementation of the direction contained in the earlier round of litigation, the subsequent repetition is maintainable, my lord. Your
No,
lordship.
no, it says in case any amount is found to be due and payable to the petitioner, the same shall be paid by the ONGC by depositing the same with the competent deputy commissioner. The deputy commissioner said your client is entitled to. That means
He
if
is
this order
supposed
is to, ONGC was required to pay the amount.
But without assessment, it will be ONGC cannot deposit, my lord.
So who is to make the assessment?
Assessment has to be made by the collector or the competent authority within the meaning of the provisions of PMP Act and Land Acquisition Act. That has not been done. Your
So
lordship will find, I am taking your lordship to the report
No,
itself.
it might sound technical, but law is technical. Technicalities come in the way.
Yes.
If it comes in the way, it will take away rights. That's how law functions. So technicality is a part of legal matters. That's why cases are being heard in court.
Yes.
Judges here and lawyers argue. Otherwise, things could have been settled in the street. I am asking you a question. And I'm asking this not to deny relief, but to understand where things are. You order dated 5/9/2011. Paragraph 6.1.
Yes.
Was anything missing there or everything that your client wanted at that stage was covered in that order?
Lord, as per that direction, an inquiry was required to be conducted, and if some amount is found payable, that has to be paid. Now, the meaning thereby is that after the inquiry, if compensation is not paid in respect of any portion of the land, the deputy commissioner has to calculate the same, and thereafter he will issue a direction to the ONGC for deposit. That part has not been done. Because as per the report, in respect of serial number 15A, land covered by serial number 15A and 23, compensation is payable. That is the clear cut. The claim is just. And in respect of certain other lands, my lord, the report says that rental and crop compensation is paid in respect of our right of user. Now, my lord, under section 10, I am entitled to 10% of the value of the land. That has not been determined, my lord. That is clear cut report in the report itself. That is revealed from the report itself. So without any.
So you are saying this report is defective?
Defective, my lord.
The reasons, number one, why it is defective?
He failed to determine the payable compensation, my lord.
And number two?
And in respect of certain plots of land, the inquiry report says that the land is purchased outright. Whereas as per ONGC's statement, the land, the pipelines which were laid over the few portion of land, those were rerouted. So according to ONGC, the land is in our possession. So there is
no determination as to how much land
is
of the petitioner's tea estate
is
was involved in the process.
Yes, ma'am.
And what is the market value?
Yes, my lord.
Or what is the valuation of the land?
Valuation that has
for
not been
computing
determined,
These two things have not been determined.
not determined.
What do you have to say,
My
Mr.
lord,
Sai?
your lordship see when these lands were, my lord, 1970 to 88. That is their
No,
statement.
no, there is an order of the court.
No,
Last time-
order, well, correct. That report itself says, my lord, if your lordship see this page 67 report, my lord, the
Hmm.
government has also filed the affidavit, my lord, same thing. My lord, they being a garden, my lord, the company should not know, my lord, where
So
from.
you are saying no compensation is payable?
My lord, if they know, my lord, where they have got a compensation, where they not, my lord. Let them specify also, my lord, their company, 2007, 1970, my lord.
Mr. Saiwala,
Yes.
what is your fundamental stand? Nothing is payable to them.
No, I am not saying that.
Then what is payable to them?
My lord, that they have to, my lord, see. Yeah. Because
They have to?
they can also say, my lord, that for this land, we have not received a compensation.
No, Mr. Saiwala,
Yes.
please, I'm seeking your assistance.
Yes,
He says my land has been used
yes,
while laying pipelines
Yes.
of ONGC.
my lord,
So I am entitled to compensation,
my lord.
which can either be calculated under the Land Acquisition Act 1894 or that Title
Pipeline Act.
62 Act. Where is
Pipeline.
that act? Give me
Yes.
the act.
Pipeline Act.
Section,
Same,
right.
my
10.
lord.
So we'll refer the matter to the district judge under 10(2).
Yes,
My lord, whether
That's
I
what I
can,
said. You want relief
whether
or
I
you want
can
an order?
approach directly without any award, my lord.
Huh?
I can approach the district judge only after passing of the appropriate award by the competent authority. That has not been done, my lord.
in one of the cases, my lord, of the same judgment, my lord, this honorable court, my lord, directed them to approach the civil court also,
Approach the,
civil court.
no, but he's saying no assessment has been made so far.
Yes.
Subsection 5 of section 10, my lord.
Yes.
If the value determined is not accepted, then I can approach me.
So pipeline was laid.
Pipeline was laid. That is the admitted position from the report itself, my lord. And in respect of 15A, he admits that this land was taken over under Land Acquisition Act. Proceedings were drawn, but payment has not been made. That is in respect of serial number 15A and 23. That is under Permanent Land Acquisition Act. Item number land covered by serial number 15A and 23. That is in the report itself.
Serial number?
15A, page 70. On verification of, may I read, my lord?
Yes.
It is found that in respect of claim at serial number such and such, the ONGC has not made the payment as per records. The claim of R&T plantation is justified in this case. Now 23, my lord. Page 72.
Yes.
As per records submitted by ONGC through though possession of acquired land measuring such and such was handed over to ONGC on 24/8/78. The LA estimate, land acquisition estimate, was not submitted by the then SDO office to the ONGC. The claim of R&T to receive compensation is justified in this case. But proceedings were not drawn in respect of these two matters.
So here we are concerned only with the 114 bighas.
Yes, my lord. And these are covered by 39 claims, my lord. Small portions of land were taken over at different point of times. And usual practice was that, my lord, before any proceeding is done either under the PMP Act or under the land, advance possessions were taken over. Around 2,000 bighas of petitioner's land was taken over by ONGC. till now.
In many cases, payments were made, my lord. Debtors on the report.
Your lordship may kindly come to serial number 12 of the claim at page 69.
So anyway, we'll ask the Deputy Commissioner Sibsagar to make an assessment.
My lord, if your lordship see, in many cases, payments were made, my lord. If your lordship comes to CL number
So
7,
if payments have been made, you furnish the particulars.
we are, my lord, it is annexed, my lord. They have enclosed. They have
So, all
enclosed.
right, the Deputy Commissioner will decide that.
My lord, your lordship may kindly see serial number 12, page 69.
You want the court to tell out that payment has been made for 1 bigha, 3 katha.
No,
Payment
my
is
lord. What
required to be
I'm-
made for 4 bigha, 5 katha like this.
No, my lord, what I am trying to impress upon the court that is that your lordship will find in respect of certain claims, rental and crop compensation. I am not denying, I have received. I am accepting, but I am entitled to get 10% of the market value as per PMP that has not been paid. This is my submission
10% of the market value
of
of the
land as per subsection 4 of chapter 10 million. And regarding 15A and 23, as per the Land Acquisition Act. That is taken over under the
which section? Section?
10
10(4) of
subsection
PMP.
4.
Uh,
That is in respect of, my lord, land covered by serial number, may I point out, my lord?
Yes.
In respect of serial number 12, land covered by serial number 12, 30, 32, 33, 35, 36, 37, 38, and 39. There is a clear admission that rental and crop compensation is paid under the PMP Act. So I am entitled to 10% land value. And in respect of 15A and 23.
One second.
Yes.
So in respect of this, rental and crop compensation
Paid.
already paid.
Yes, my lord, that has been received.
You are entitled to 10% of the market value.
Market value of land.
So this is regarding items 12, 13, 32, 33, 35, 36, 37, 38, and 39 of the report.
Yes, my
Or
lord,
the
of the
Deputy
report,
Commissioner.
as per the report. My claim is as per the report.
Yes. And what
And now
else?
in respect of 15A and 23, land covered by serial number 15A and 23, I am entitled to compensation as per the provisions of Land Acquisition Act. And since,
Get the act, please. Land acquisition. Yes.
my lord, now this will
Land
be-
Acquisition Act 1894.
my lord,
Yes.
now since that has not been determined under that act, my lord, so compensation as per section 24(1)A has to be determined under the 2013 act. my lord.
Where is the 2013 Act? Fair
Section
compensation.
Section
Fair-
24, yes, Mr. Right to section 24(1)A of the new act.
So why are you saying 114 bighas? This
Total, this is total land, my lord, in respect of 39 strips of land. my lord.
And this 114 bigha was used for drilling purposes or laying pipeline?
For the purpose of laying, and sometimes the land is taken over for on permanent basis. When they extract gas, my lord, that is required for permanent use. my
So
lord.
for exploration and drilling
Exploration,
and
yes.
laying of
Yes.
pipeline, all purposes.
Yes, yes.
Let the Deputy Commissioner examine the matter and pass appropriate order.
My lord.
This time we'll ask him to determine the amount of compensation, make an assessment. And
Where
then,
it has not been paid, my lord. Where it has not been paid.
all right.
As per the report, you have given the serial numbers.
Take on heard Mr. S. K. Kejriwal, Learned Counsel appearing for the writ petitioner. Also heard Mr. G. N. Sahiwala, Learned Senior Counsel assisted by Mr. Anix Singh, Learned Counsel appearing for the respondent number 1. Mr. B. J. Talakdar, Learned Senior Counsel assisted by Mr. P. K. Medhi, is present on behalf of the respondent numbers 2 and 3. Full stop. This is the second time that the writ petitioner had to approach this court by filing this writ petition, making more or less and seeking more or less similar nature of relief. Full stop. The facts of the case leading to the filing of the writ petition briefly stated, are to the effect that the writ petitioner is a company carrying on business inter alia of plantation, manufacture and sale of tea. Full stop. For the purpose of carrying out the aforesaid business, the petitioner company owns Lukwa, L-U-K-W-A-H tea estate situated in the district of Sibasagar. Full stop. As per the case projected in the writ petition, several plots of land falling under the petitioner's tea estate has either been used temporarily or permanently by the respondent number 1 for the purpose of activities such as exploration of oil and gas, activities such as drilling for exploration of oil and gas, and also for payment of and also for laying down pipelines. Full stop. In the process, land measuring 114 bighas, 1 katha and 19 lechas belonging to the petitioner, belonging to the Lukwa tea estate has been permanently utilized by the respondent number 1.
Not permanently, madam. Not all.
Has been utilized by the respondent number 1 in various formats. Full stop. Full stop. The petitioner has been paid rental and crop compensation for the land. However, since no compensation as required under section 10(4) of the petroleum and minerals pipelines acquisition of right of user in land close Act 1962, as well as the compensation payable in terms of the provisions of the Land Acquisition Act 1894 had not been paid to the petitioner. Hence, the petitioner company had earlier approached this court filing WPC number 4117/2011. Inter alia praying for a direction upon the respondents to pay compensation to the petitioner in respect of the 114 bighas of land by assessing the compensation for the damage caused to the land. In addition to other relief prayed for in the said writ petition. Full stop. Since the petitioner has confined its grievance only to the question of payment of compensation for the 114 bighas of land allegedly used by the ONGC, that is the respondent number 1, it would not be necessary for this court to go into the other aspect of the matter agitated in WPC number 4117 of 2011. Full stop. By the judgment and order dated next paragraph, judgment and order dated 0509/2011, the learned single judge had disposed of the aforesaid writ petition, wherein the relief prayed for by the petitioner company pertaining to the 114 bigha of land was dealt with in paragraph 6, subpara 1, which is reproduced herein below. Page 55, you will get it, double tick to double tick. First time. In terms of the directions contained in the order dated 5/9/2011, the respondent number 3, that is the Deputy Commissioner Sibsagar, now that is the additional Deputy Commissioner Sibsagar, had prepared a report dated 31/12/2011, which was forwarded by the Deputy Commissioner of the district to the respondent number 1 as well as the petitioner. First up, the grievance of the petitioner is that although the enquiry report dated 31/12/2011, is it 31/12/2011? Although the enquiry report prepared by the respondent number 3, which was forwarded on 31/12/2011, clearly indicates that the petitioner was entitled to receive compensation, no action has been taken by the respondent number 1 for payment of compensation. Stop. Aggrieved thereby, the present writ petition has been filed. By referring to the enquiry report prepared in terms of the order dated 5/9/2011, passed by this court. Mr. Kejriwal, learned counsel for the petitioner, submits that the report clearly indicates that with regard to item numbers 12, 13, 32, 33, 35, 36, 37, 38, and 39. Only the rental and crops compensation have been paid to the writ petitioner, but no compensation on the market value of the land as provided under section 10(4) of the Act of 1962 has either been assessed or paid to the petitioner till today. Full stop. Mr. Kejriwal further submits that with regard to item numbers 15A and 23 of the enquiry report, since the land was acquired on permanent basis, hence the petitioner was entitled to compensation under the provisions of the Act of 1894. Full stop. 1894, which has not been done, which has also not been done till today. Full stop. Contending that since no assessment was made as per the Act of 1894, hence assessment of compensation would now have to be made under section 24
1A.
bracket 1
Bracket A.
capital A, is it?
Small.
24
Subsection 1. Close it.
24 subsection numerical 1 bracket close, then no assessment or award has been passed under the Act of 1894. Hence, the value of the land would now, hence, in view of the provision of section 24, bracket numerical 1, bracket close, bracket small a, of the right to fair compensation and transparency in land acquisition, rehabilitation and Settlement Act, 2013. Fresh assessment of the land, the value of the assessment of compensation payable in respect of the above land would now have to be made as per the provisions of the Act of 2013. Full stop. The learned counsel for the petitioner has therefore submitted that a direction be issued by this court to the Deputy Commissioner, bracket District Commissioner. He's not even a party here.
Sipsara,
He's not even a party.
party,
Yeah,
he is a party.
he's a party.
Yes.
With respond number
Competence, respondent to competent authority,
Mm,
deputy commissioner.
To the respond number 2. Bracket redesignated as District Commissioner. Bracket close. To carry out the above action and complete the formalities by clearly making an assessment of the amount of compensation receivable by the petitioner. Thereafter, a direction be issued to the respond number 1 to release the amount of compensation without further delay. Full stop. Responding to the above arguments, Mr. Sahiwala, learned senior counsel for the respond number 1 submits that since the usage of the land has been going on since past 4 or 5 decades and in bits and pieces, it would be wrong to say that the petitioner has not received any compensation. The learned senior counsel for the respond number 1 has, however, fairly submitted that if any amount of compensation is due and payable to the petitioner under the law, his client would not shy away from paying such compensation, provided proper assessment of the same is made by the competent authority by following the due procedure as laid down by law. Full stop. Similar as the stand of Mr. B.J. Talukdar, learned senior counsel appearing for the respond numbers 2 and 3. Full stop. After going through the materials available on record, I find that the enquiry report prepared in terms of the order dated 5/9/2011 elaborately deals with the claim of the petitioner for payment of compensation. In the enquiry report, the compensation payable to the petitioner for each and every parcel of land corresponding to the different items have been reflected. However, unfortunately, the enquiry report does not reflect the amount of compensation that would be receivable by the petitioner on a proper assessment of the market value of the land. Full stop. If that be so, it is clear that the enquiry report forwarded on 31/12/2011 did not complete the process necessary for release of amount of compensation payable to the petitioner. Full stop. After a careful reading of the provisions of section 10(4) of the Act of 1962, as well as the relevant provisions of the Act of 1894, as well as Act of 2013, this court is left with no manner of hesitation that before any direction can be issued by any authority for release of amount of compensation, first a proper assessment of the land and the compensation would have to be made by the competent authority, which in the present case is the respondent number 2. Full stop. Therefore, without expressing any further opinion on the claims and counterclaims of the parties, this writ petition is being disposed of with a direction upon the respondent numbers 2 and 3 to make assessment of the amount of compensation payable to the petitioner by following the prescribed procedure laid down in the Act of 1962. Insofar as the claim for payment of 10% market value of the land as projected herein above is concerned. Full stop. Insofar as the amount of compensation claimed with regard to item numbers 15A and 23 of the enquiry report, the respondent numbers 2 and 3 shall examine as to whether the aforesaid claim would be accessible under the provisions of the Act of 2013, and if satisfied on the in that regard, may proceed to make assessment of the amount of compensation. Full stop. Facilitating the above, the writ petitioner as well as the respondent number 1 may present relevant documents and other records before the respondent number 2 in support of their respective claims within 3 months from today. Full stop. Thereafter, the respondent numbers 2 and 3 shall complete the process of assessing the amount of compensation, prepare a report, and then send and make an award, is it?
Yes.
And thereafter proceed to pass an award in respect thereof. The aforesaid exercise be completed within an outer limit of 6 months from the date of receipt of a certified copy of this order. With the above observation, this writ petition stands disposed of.
Lovely.
So there's a 60. Here.
Item 13.
Yes.
That's it, Your Honor. My lord, this is a writ petition, my lord, against government and 3 individual persons, my lord. This is a writ petition.
Your lordship's order in dated 29/8/2019. The third page, yes.
Who is the counsel for respondent number 7?
From your lordship's order, it reflects that Mr. B. Sarkar. His name is also shown.
Shown in the.
DJ Kolita and B. Sarkar.
My lord, about 3 months back, my lord, I got B. Sarkar here. Now he is not practicing in the High Court, he is now practicing in Bongaigaon Court, my lord. And he inquired that what happened to this case, my lord. That I told him it is still pending, it has not been disposed of. And I inquired from him whether he had returned the file to the respondent number 7. He was engaged by respondent number 7, my lord. But he told me that I have already talked to him and I am left Guwahati for Bongaigaon, my lord.
No, but we cannot decide this matter without the respondent number 7. He will come and if there is any order of payment of compensation, then he'll come and review. What to do? Either we can issue fresh notice or have a legal aid counsel.
It is better to issue a fresh notices because if the counsel is not appearing, if on the next day also lordship is not appearing, nothing will come out.
My lord,
Financial matters, he will not.
one more thing, my lord. On respondent number 7, several times notice has been issued. Lastly, my lord, I was ordered by the honorable court to arrange dusty service of notice on the respondent number 7, my lord. Then I engaged 2 persons, my lord, and they failed to serve the notice. Then I myself personally went to the respondent number 7, my lord, and I have handed over him the notice. And I have filed an affidavit here, my lord, that notice has been served on him. Now, he is not taking steps, my lord. He is not very much interested here. Only at earlier stage, respondent number 8 and 9, his agents
appeared before Sanmari police station and undertook and made a mutual understanding to do certain things, my lord, but they have not done it. Now, if you can notice it, sir, my lord, it will take much time, my lord.
I will pass an order, but it will never be implemented.
Yes.
And therefore, your stand doesn't appear to be very responsible, Mr. Chaudhary. You just want to get rid of the file. We are not interested in this stance. What is the matter about Mr. Sharma?
Lordship, there was a boundary wall, Lordship, retaining wall was constructed by the petitioner, Lordship, and that was demolished by the respondent. This by the agent of the respondent, that is respondent number 7 and 8, Lordship. Thereafter, they lodged an affair before the before the Sanmari police station. Accordingly, they have mutually agreed that the respondent number 7 and 8, they will construct the wall, the retaining wall, so that the landslide doesn't occur again, and that gaps will also be filled up. But that was half constructed. The petitioner, they constructed the rest part. Accordingly, they are agreeing to pay the compensation to the petitioner.
Then what is the problem?
He is not paying the compensation, Lordship. And regarding that, Lordship, we have been directed to make an inquiry. In the inquiry, it was found by the circle officer as well as the forest department that the wall constructed by the respondent also, that was without any authority, Lordship, without there being any permission. That is why, Lordship, the GMD is also a party.
Then we'll ask the GMD to break down the wall
Lordship.
if they don't appear.
But I think GMD, they have got standing.
Is anyone there for GMD? And is there a police case registered?
Police case, most probably it was a complaint, Lordship. Accordingly, they have called both the parties, and as it was mutually settled that they will make the construction, so it was dropped. That is the in the inquiry report it was found.
At page 26, my lord, that mutual understanding and understanding at page 26, my lord.
Acha, see if you can call the GMD council.
Lordship.
We'll ask them to examine the matter and take
Lordship.
steps.
Lordship. After
Because
some
if-
time,
if, we'll find a way to
Lordship.
grant relief, but we'll see.
Today itself,
Let
Lordship.
the GMD issue notice and break down their wall. You wait for a little while.
Lordship.
Let him come then.
I'm here. Lordship.
Can you, if the GMDA council comes, can you please brief him or her? little bit? Today, we are not passing any order, just fixing it after a week. Let them examine and then, yes, next matter.
Item 14 and 15.
Lordship, we are yet to receive the records, my lord. It was called for. And we made communication on only on my lord 4/8/2023. So we're waiting for it.
Record call for this last matter was last taken up on
Hard up,
January.
hard up. That order sheet that was not there, not reflected. However. No, 3/8/2023.
What is this matter about?
Land acquisition, my lord, in last time your lordship heard for few minutes. In Sangsari, my lord, for construction of the ROB. And last time when the matter being heard, my lord, just few minutes, then the lordship wanted to know the fact about the records, my lord, then the government advocate committed to produce the record next time. On the next day fixed.
Case number 6. 6 and part 6 part.
LA case number 6 of 89 and LA case number 6/89
Part.
part. Two cases, records are necessary.
What is the relief you are claiming here?
My lord, compensation for Gerard.
Huh?
Gerard. Compensation for Gerard.
Compensation, read court cannot give it. You go to the deputy commissioner.
No, we have, my lord, there are really very long checkered history since 1994.
Hmm.
Deputy commissioner approach, government is approach.
No,
government-
are you saying the High Court will determine the Gerard?
No, no,
Then?
I am not asking for Gerard.
Then?
They have determined the Gerard. Payment is only due.
Hmm.
That's why your last time I want to see the record from the government.
Payment is due means what? Who is supposed to make the payment?
The NSI
Hmm.
and my lord, the through deputy commissioner.
NHI.
Yes. So far land part is concerned, there are 2 bighas of land, my land. They have already, they have in fact acquired in paper all 2 bighas. Ultimately, they use only 1 bigha, 3 kattha.
You mean to say National Highway Authorities?
Yes.
They are not parties in your proceeding.
No, PWD, at that time only there was no NSI, didn't acquire it. It was on the suggestion of the PWD, DC did it.
Yes, petitioner's land has been acquired for construction
Land
of
part
road.
they have paid, only that.
Construction of overbridge in railways.
Hmm. Then what happened? Why the payment is not being made?
Regarding payment, government, because we are implementing agency on
Hmm.
on that project. Land acquired by the government.
Hmm.
And
It was acquired for construction of railway overbridge. Then the railways will have to be made parties. They are the ones who will have to make the payment.
No matter. What happened, the overbridge are constructed by the, maybe with the, in partnership with the railways also, but PWD. PWD was.
Mr. Sharma, you want an order or relief for the client?
I want my lord, already payment for land has been made.
Hmm.
So far acquired. 2 bighas was acquired. Ultimately, they used only 1 bigha, 3 kattha. 2 kattha they didn't use. I'm in occupation. I'm staying there. I've got house and other things. For that, there were 50 oil mills. Everyone knows 50 oil mill, my lord. The factory was demolished. Without even, my lord, assessing how much land they would get required. In fact, ultimately they required only 1 bigha, 3 kattha. 2 bighas with me. Now that Gerard, the demolition of the 50 oil mill and the wall of machineries, that part remains. They have already made the assessment. They have said. So let them get clear instruction, matter what is what.
All right.
Then you will.
All right. Heard Mr. R.P. Sharma, senior counsel appearing for the petitioner. In both these petitions also heard Mr. Bijay Talukdar, learned senior counsel assisted by Mr. P.K. Dekkan, and counsel representing the Respond number 2, respond number 2, and Ms. S. Sharma, learned standing counsel PWD for respond number 3 and 4. Ms. G. Hazarika, learned SC Revenue Department Assam is present on behalf of respond number 1. Mr. Talukdar submits that records would be necessary for disposal of this writ petition, but the departmental records are not available with him today, till today. Are not available with him today. Therefore, a prayer for adjournment has been made in these cases for 4 weeks so as to enable the learned departmental counsel to obtain the records. Having regards to the nature of controversy involved in this writ petition, this court is also of opinion that perusal of the records will be necessary for deciding the cases finally on merits. As such, hearing of these matters stand adjourned for 4 weeks. The learned government advocate Assam to positively call for the records and produce the same for perusal by the court on the next date of hearing. List the matters accordingly.
Banking member, item 13.
Acha, Mr. Bora.
Lordship,
prior
to that, Lordship, from my learned friend, I have, he has told me that it is the boundary wall of the, that retaining wall of the petitioners were constructed by him, but there was no such any construction by the respondent authority. So question of their GMDA demolition doesn't arise, Lordship.
No, but boundary walls will have to be constructed by obtaining permission.
Yes, and according to my learned friend lordship, that I, at the time initially when it was constructed, the building as well as that retaining wall,
Hmm.
that permission was there. Thereafter, when it was demolished by the respondent,
Hmm.
thereafter, when it is constructed, lordship, there was no such any
So
permission.
then what can the rate code do here? This
Yes,
is not
lordship,
a
regarding the
subject matter.
compensation part, lordship has nothing to,
It has
most
to go to
probably,
civil court.
civil code,
It's a private dispute. Private
It's a
dispute.
private dispute.
lordship. Only that part is there, lordship, I have gathered, which my learned friend has stated to me,
So he is appearing as legal aid counsel.
lordship.
You go to the civil court, rate court can't do anything.
পাৰে যদি মানুহজনক আনিব,
Huh?
let the matter be kept pending for some more time, let him once try.
The respondent number 7, my lord,
Hmm.
I may be excused. He is the managing director of Allcare. Mines, my lord. Now, when I personally contacted him, my
Why are you getting personally involved? You are also part of the, you own a part of the land or something? No. You are a legal aid counsel. You are a legal aid counsel.
Any legal aid counsel hai.
Yes, madam.
Then why are you getting personally involved?
No, I'm a legal counsel. Huh?
They'll make you a witness. The council is not supposed to get personally involved. Anyway, what is the prayer? These are all, I don't know how these matters have been filed before the High Court. Completely.
Okay.
What is the representation? Which representation?
Good, you say?
Which representation?
Representation of what is it?
Card representation.
GMD এগুলো দিছিলে এখন।
The representation before Commissioner GMD, my lord, at 28 pages.
It's 20.
GMD হব নহয় এটা, this is C.
বাৰু যিয়ে নহওক। Yeah, নাই আৰু এইবিলাক, they have constructed. He has already constructed all these things, lords. Only that compensation part remains now.
Compensation rate code.
Lordship, that cannot be lordship.
Yes, take down.
Lordship.
Mr. B. Chaudhary, is it? Mr. B.C. Das, learned legal aid counsel is present on behalf of the writ petitioner. Mr. H. Sharma, learned additional senior government advocate Assam,
Respondent number 1.
has appeared on behalf of Respondent numbers-
1, 4, 5, 6.
one. Why not superintendent of police?
Yes, lordship, for 5,
Yes.
5 and 6,
1, 4, 5 and 6.
lordship.
Mr. S. Bora, learned standing counsel GMDA is present on behalf of respondent numbers 2 and 3. None has appeared for the respondent numbers 7, 8 and 9. Although the respondent number 7 was earlier represented by Mr. B. Sarkar. Full stop. It appears that respondent numbers 7 and 8 are the owners of a plot of land situated on the western side of the land of the writ petitioner. Full stop. The petitioner's land is situated at the near the Navagraha temple at Guwahati and is covered by dag number 230 bracket new bracket close of KP Patta number 1 of Revenue Village Kharguli under Moja Ulubari, Kamrup, Assam. According to the petitioner, she had demolished a portion of her western boundary wall so as to facilitate construction of house by the respondent numbers 7 and 8 in their adjoining plot of land. Full stop. However, taking advantage of the absence of the petitioner, the contractor engaged by the respondent numbers 7 and 8, that is the respondent number 9, had broken down major portion of the wall, had broken down almost the entire boundary wall, thus causing financial loss and injury to the petitioner. Full stop. The petitioner had submitted a representation dated 18/5/2011 before the GMD authorities, ventilating her grievance in the matter, but since no action was taken by the authorities in that case, hence the present writ petition has been filed. Full stop. Mr. Das, learned legal aid counsel, submits that the petitioner has already constructed the boundary wall, and at this stage, all she is seeking is compensation, monetary compensation from the respondent numbers 7, 8, and 9 for causing damage to her wall. Full stop. Mr. H. Sharma, learned additional senior government advocate, Assam, and Mr. S. Bora, learned standing counsel, GMD, has submitted that the matter submitted that this is purely a private dispute between the petitioner and her neighbors, that is the respondent number 7 and 8. And since the boundary wall has already been constructed, at this stage, there is no scope for the authorities to interfere in the matter. Full stop. After going through the materials on record and after hearing the submissions made by learned counsel for the parties, this court is also of the opinion that the issue agitated in this writ petition at this point of time is nothing but the fallout of a private dispute between the petitioner and the respondent number 7 and 8. Moreover, prayer for respondent number 7 and 8. Therefore, the basic relief sought for in the writ petition, which is for issuing a direction upon the respondent numbers 3 and 4. 3 and 4 or 2 and 3?
2 and 3.
Respondent numbers 2 and 3 to consider the representation dated 18/5/2011 submitted by the writ petitioner cannot be granted in the facts and circumstances of the case. Moreover, there is no prayer for payment of compensation to the petitioner in the writ petition. Full stop. Even if such a prayer is made, the same cannot be entertained by the writ court under Article 226 of the Constitution of India, since such a dispute can be adjudicated only by the civil court in an appropriate proceeding. Full stop. Therefore, this court is of the opinion that there is no scope for the court to grant relief as prayed for by the petitioner in this writ petition. As such, the writ petition stands disposed of by granting liberty to the petitioner to approach the civil court seeking appropriate legal remedy if so advised. Nothing can be done in the writ court. Yes. No party list. So,